Yes, Mr. Muzana, we welcome you back into the interview room. I will ask you the first question, which is in two parts. The first part, what is the effect of a declaration of constitutional invalidity of any law by the High Court in a constitutional application? And the second part, state any two procedures by which an order of constitutional invalidity or validity by the High Court may be brought to the Constitutional Court for determination. State any two procedures by which an order of constitutional invalidity or validity by the High Court may be brought to the Constitutional Court for determination.
The law that they've declared to be invalid will continue to be in place until the invalidity is confirmed by the Constitutional Court. Then the second part was talking about the procedure by which an order of constitutional order of validity or invalidity may be brought to Constitutional Court for determination. The first way is where the matter is referred to the Constitutional Court for it to confirm or to not to confirm the decision of the High Court itself. That would be the first way in which a matter which has been declared to be, where the constitutional validity has been confirmed by the High Court, goes to the Constitutional Court. Then secondly, it can also go to the Constitutional Court if there is a party which is not happy with the determination that has been made by the High Court. Then in that case, the party will refer the matter to the Constitutional Court to be heard if they feel that there is a constitutional infringement in the decision that has been passed on by the High Court. Those will be the two ways by which the matter may end up at the Constitutional Court.
The second question is also in two parts. The first part, what are the exceptions that must be taken into account by a court when deciding whether or not to grant specific performance in a contractual dispute? The second part, what is the test which a court applies in the determination of an application for absolution from the instance?
Thank you, Justice. I will start with the first one, the exception that must be taken by a court when it is determining a contractual dispute. The exception that I would start with, number one, it is checking if the contract itself was legal. If the contract is illegal, then the court cannot determine that which is illegal. It will be an exception that the court can deal with and dispose with the matter or not continue with the matter because the matter will be illegal and it cannot be heard by the court. And also another exception is the possibility of performance. If the contract that the parties has entered into cannot be performed, if performance is not possible, it means the court cannot proceed with the matter as the determination will be academic. It will not resolve anything as it will be rendered academic as the performance will not be possible to be performed by the parties. And then the test for absolution from the instance. Actually, absolution from the instance is in a civil matter where upon the plaintiff has finished to give his or her evidence and he wants the court and the defendant would want the matter to be disposed at that point, and the test would be actually in civil matters, or actually it will be on a balance of probabilities as in all civil matters, and as it is on a balance probabilities, we are checking if the defendant's case, if the plaintiff's case, or if the plaintiff has managed to prove or he has a case that needs defendant to be called to come and give his case. Therefore, on an absolution from the instance, the idea is to say the plaintiff has failed to prove a case on a balance of probabilities, and therefore there is no reason why the defendant should then be put to his defense and answer to the claim of the plaintiff.
The third question is in three parts. The first part, state any two components of a sentencing judgment. The second part, how does a sentencing judgment under the sentencing guidelines regulations differ from the previous practice of giving reasons for judgment? And lastly, what is the role of the victim impact assessment statement?
Sorry, Chief Judge, on the third one.
What is the role of the victim impact assessment statement?
I will start with the first one, which talks to the two components of the sentencing judgment. The sentencing judgment would look at there is number one, we look at the sentence itself, the level of either imprisonment or fine that is given to the person who has been convicted, and the other component would look at the components. Actually, I'm sorry, I will take the two components. We look at the mitigation and the aggravation. On the mitigation, we are looking at the factors which would make the sentence to be lighter, and on the aggravation, we'll be looking at the factors which would make the judgment to be heavier. Those will be the two components that I would put to say we've got the aggravatory factors and the mitigatory factors which are considered by the court in order to come up with a sentence that is appropriate, a sentence that would reflect on the charge that have been, the crime that have been committed, as well as the person that is being punished. Those would be the factors, the two components of the sentencing that I would give. Then I would go to the second part, which deals with how the sentencing judgment differ, the current judgment, how it differs with the previous judgment. Number one, we now have the sentencing guidelines which have been given which have been given to the court, and these guidelines, they assist the court to come up with a proper sentence. In so doing, we have got the presumptive sentences which have been put into consideration, and the presumptive sentences are the starting point wherein the court has to look at the presumptive sentence and look at the mitigation that will be given by the accused person and see if they can go below the presumptive sentence given, or they would go look at the aggravation that have been given by the state and see which sentence is proper. So this is a new issue that have been incorporated, that of the presumptive sentences. Then secondly, the other difference would also come to the minimum mandatory sentences which have been given in some cases, just like if I give an example of rape. Now we have got, where it is mitigatory, we have got a minimum mandatory sentence of 5 years, which was not there before. And this is a new thing that is affecting the sentencing judgment that are being given by our courts. Even the issue of the involvement of the victims in the sentencing, where the victims are coming in to give their side and assist the court in coming up with a proper judgment. That will be part of the difference between the sentencing of previous years with the sentencing of the current regime that we have now. Then I will finally deal with the role of the victim impact assessment. Actually, the role of the victim impact statement is on the victim coming to the court, explaining to the court how he or she has been affected by the crime that has been perpetuated against him or her. This would assist the court in that in the previous sentencing, the court would look at the effect of the judgment in a way which is a bit arbitrary, without asking the victim him or herself to come and give the court. And this statement of the victim is very important in that it would now marry the convicted person and the judgment that will be given. You'll see that where the victim has been affected not very much, it will also be reflected in the judgment that will be given. Where, for example, the victim comes and says, I've already forgiven the accused, the convicted person. Then the court will still punish the accused person, but also putting into consideration the intention or the need of the victim himself or herself. And therefore the victim impact statement is very important. It assists the court to come up with a proper judgment that is in line with the effect that the crime has caused on the victim himself or herself.
The last question, which is in two parts. The first part, how have the High Court Amendment Rules 2024 addressed the key concerns of access to justice on the IECS platform? The second part, state 3 ways in which the IECMS has revolutionized civil litigation in Zimbabwe.
Sorry, on the last part, is it only civil litigation? If I had the question well. The last part was it is revolutionized civil litigation.
Yeah.
Thank you. So firstly, I'll deal with the amendment of 2024, which actually was causing effect on the ICMS platform. Firstly, the amendments addresses on the issues or the problems which were there before its enactment. One of them being the issue of hybrid, the hybrid system, wherein we may have one person not having access to on the internet, and that person may come to the court physically, and then if one person also has got access to the internet, the person will be far away but able to access the ICMS system and allow the proceedings to go on. Again, there is also the issue of consent, where the parties can consent to be heard on the ICMS system. If they've given that consent, actually this would resolve the issue of saying, are the people having the are they having the internet? If they don't, then how can they be assisted? Actually, our ICMS is still new, it's still being, its teething problems are being resolved by the High Court or by the judiciary in a way of trying to make sure that the people will get a service that is unparalleled. And this is being done through these amendments, wherein the system is actually trying to make sure that the people will get a proper service and litigate their matters without any problem. And therefore, the issue of which I've already spoken about, of the people coming, some coming for the physical and others being on the virtual, or all of them being on the virtual, but still making sure that the people will be heard at the end of the day, which is the role of the court to make sure that each and every one of them are heard at the end of the day. So these are how the amendments have come in, and also would see the speed resolution of the matters which caused by the ICMS. Then 3 ways in which the ICMS has revolutionized the civil litigation. Firstly, I'll deal with speed resolution of matters. Now that we have got the ICMS system, we see that after the service of the summons, all the other processes can be served fastly through the ICMS system, wherein if a person is given a notice to plead, where people would be having problem in serving the people with their papers. Now it is very simple and it can be done fastly in the matters. And I do believe that our role will be cleared. We won't have the overhang of materials which would not have been had. After the speed resolution, we also have convenience. The people are now filing their papers whilst they are in their offices or they are at home. As long as they've got the ICMS, they've got the internet, they are able to file their papers speedily. They are able to do that without any delay, as they will be doing that while they are in the comfort of their homes. And also, it has also removed the issue of saying, since somebody saved papers, they are even outside of the country, they can still respond to the papers. They can still respond regardless of where they are. Therefore, it has also brought convenience to the people. They can file their papers in a manner which is fast, without unnecessary delays being caused by wherever they are. So the ICMS have actually revolutionized the civil litigation. It have made litigation to be easy. It have made litigation to be fast. It have made litigation to be convenient. Therefore, the people are now able to deal with their matters as early as possible and make sure that we have got fast resolution to the matters.
Yes, thank you. I will now hand you over to the other commissioners for further questioning.
Thank you.
Yes, TCJ.
Thank you, CJ. Good afternoon, Mr. Muzana.
Good afternoon, Deputy Chief Justice.
I have two questions for you.
Thank you.
The first one, in the questionnaire that you filled in, you state that you started practice in 2016. That is 8 years ago. And added to this, it appears that you do not have judicial experience. You were never a magistrate, it seems. So the question I'm asking is do you think on that basis you are adequately prepared in terms of experience to join the High Court bench?
Thank you, Deputy Chief Justice. Actually, I joined the practice in 2016. That is very correct. Before that, I was a teacher, and since 2016, I've been practicing in our courts, mainly the Magistrate Court, the High Court, and with some cases in the Supreme Court. I've actually weighed in to look at the demands of the judiciary, wherein there is need to have an in-depth understanding of the legal principles. Actually, I've also lectured law, though at a college that is Zimbabwe Institute of Legal Studies. I've interacted with the law, and I do believe that I will be sufficient when it comes to delivering judgments. And as I am also available to learn where learning will be needed, but I've actually looked at it from that perspective of saying I've looked at the law, I've looked at the judgments which are being written by our courts, I've looked at even the matters which I've gone with to the courts, and see that if the panel would see that I'm sufficient High Court judge, and I will be able to deliver and do the best that I can for my country.
Yes, thank you. The second question now, does the High Court have jurisdiction to hear constitutional matters? And if so, what are the limitations to this jurisdiction, the limitations?
Thank you, Deputy Chief Justice. Actually, the High Court has the jurisdiction, yes, to hear constitutional matters. They can hear them, pass a determination, but this determination will need to be confirmed by the Constitutional Court itself. And therefore, the first part I've actually put it in the positive to say the High Court has the power and authority to hear the constitutional matters. And then I would look at the limitation that the High Court has. Firstly, the first limitation is in the judgment that will be given by the High Court itself. As I've already said, that judgment will still need to be confirmed by the Constitutional Court. And therefore, it's not like it passes a judgment, that judgment becomes operative. And secondly, there are matters which are specifically directed to the Constitutional Court. Just like if we are to deal with the issues, let's say, a very good example being if there is a problem on actually just like, let's say, if we are looking at the executive, when we are looking at the decisions which are passed by the president, if they are to be challenged, they have to be challenged in the Constitutional Court, not in the High Court. In as much as the High Court can hear constitutional matters, it is limited by the Constitution itself to matters that it can hear, which are arising from the Constitution itself.
Yes, thank you.
Indebted.
Thank you, Chief Justice, and good afternoon to you.
Good afternoon, ma'am.
Yes, looking at your CV, I can see that you have studied automotive engineering. You have also ventured into banking. You have also done diploma in education, and lastly, you also studied law. That makes you a jack of all trades, so to speak. Now my question is, what then prompted your decision to want to settle into the highest judicial office, that of a judge, given your various qualifications in other industries?
Thank you, Commissioner. Actually, my interest in law, actually I've studied those 4 areas that you have listed, and I've made my decision to endeavor to be a High Court judge with those qualifications, because actually the bench actually should be reflective of what is happening in the society. We know those areas that I have actually can enhance my understanding of the society that we are in, and it will actually assist me in understanding those society, to understand the society, and also give rulings which are actually touching on those areas where I've got expertise in. Actually, the various areas where I've studied, actually they become a positive because they make me to see society from a broader perspective.
My second question is, can you state 3 principles that govern the conduct of virtual proceedings?
Thank you, Commissioner, and I will start with the number 1, which is accessibility. The virtual proceedings should be accessible to the generality of the people. A court is there for the people, and therefore the people should be able to access the court through the virtual system, and therefore there is need for people to have the internet That's why actually I've seen our courts have installed gadgets at the court for those who have got a limitation in accessing the internet. They will go to the court and still achieve to access the court even at the expense of the judiciary, and therefore accessibility is one of them. Number B, it is actually on the availability of the gadgets which actually the registrar of the High Court, like I've already said, have made sure that we have got gadgets at the High Court, which are there, and the people of the staff who are put at the High Court to assist the people who, because we know we have got people who are not good with the internet itself, and they should not be excluded from the judicial system just because we have now moved to the virtual system. Although with the time...
Confine yourself to the principles.
Oh, thank you.
You've given me two. Can you have the
Thank
third
you.
one?
The third is, I've given the one which was on the gadgets, and the last one on these ones will be fast resolution of matters. Speed resolution of matters is a principle that the people will be filing their papers in time, and therefore the matters will be resolved fastly. Those will be the three principles. Indebted.
Thank you, Chief Justice, and good afternoon, Mr. Muzana.
Afternoon, Commissioner.
Yes, before I get to my question, I just wanted to clarify this. So from 2016 to 2020, you were an associate, an employee. You're not a partner.
That's very correct.
Okay. So that if we are to understand it, you started running your law firm as from 2020, and then which makes it 4 years to date, isn't it? About that.
That's very correct.
Okay.
Commissioner.
May I find out as well the size of your law firm, which you are running, and how many partners and how many associates?
We are actually two partners. It's myself and Mr. Tapera. We are the partners, and we've got only two associates.
I beg your pardon?
We are two partners and two associates.
So they are 4 legal practitioners?
Yes.
Okay, that's fine. Then my next question to you is this. What are the procedural steps that ought to be taken by a litigant who desires an amendment to their pleadings?
The procedural steps that need to be taken firstly is once the pleadings have been done and now they are closed, it means we need the leave of to have them amended. Therefore, the litigant who need to amend the pleading have to make an application to the court and be allowed to amend their pleadings.
Thank you, and thank you.
Thank you, Chief Justice. Mr. Muzana, do you have a current practicing certificate?
Yes, I do.
Because the one in my papers expired on December 2023. Do you not have a current certificate when you submitted the papers?
I did current one. Actually, I had already read my. Actually, if I submitted an outdated one, actually it was an error.
Okay. What were you doing in the years 2016?
18 and 2016. In 20, then in to Zimbabwe, then I in 2016.
Engineering in 1990, you got a certificate in banking in 5, you got in 2006, you got your Bachelor of Laws in 2013, and you are a published poet. That diversity to indicate that you are not sure what you want to do with your life?
I did diesel plant fitting, that is automotive, 1997, and trying to find work. Then actually the job market was dwindling. I then joined the banking sector in 2002. After joining the banking sector, that's when I did my certificate in banking, which I even feel when I was already studying education. I went to a Judicial College in 2005, where I graduated in 2006 and finished. Then after that, I had an interest to study law. Actually, when it was by my then I saw there's another field can actually pursue, that was law. So I then started to study law in 2000 when I get Africa. When finances were now allowing me to do that, I then studied law. Actually, writing is a passion. It's actually not, I never took it as a career. I write poems, yes, I am a published poet. I write poetry. I've published more than 10 books, but it's something that I do as a hobby, something that I do take as a hobby that I can do.
What I want to understand is there a chance that after another few years you'll decide you've interest in something and go off and pursue something totally different? Because none of these things relate to one another. Everything is different. How can we be sure you want to do and you won't be going off to pursue something?
Actually, as I said, I found my foot in law. I've pursued law with the passion. Actually, since 2018 up to now, that is 2020, my 9th year of practice, and actually even my endeavor to be a judge simply shows that I've got love for the law.
Are you aware of the marks you scored in the test you wrote in the first phase of these interviews? The marks you scored.
Marks?
Are you aware of the marks that you scored?
Yes, actually, I am aware.
But those marks do not indicate that you are a practicing lawyer, because you scored very low on procedure. Did you not?
Actually, I've not yet been we only shown the marks that I scored 59%. Nothing else was shown.
So you are not aware of the breakdown of those marks?
Of the breakdown, yes, I'm not.
There is a question you were asked on the questionnaire which says, what would you regard as your most significant contribution to the law and the pursuit of justice in Zimbabwe? Can you answer that question now?
Yes.
What would you regard as your most significant contribution to the law and the pursuit of justice in Zimbabwe? I ask you that question because the answer does not answer.
Actually, I've practiced much more in criminal law, and I've gone to the criminal law up to the Supreme Court, and on that answer where I wrote on that, I actually wrote about the issue of where I represented people when I went to the High Court, where in the matter which I lost in the magistrate. It was actually overturned in the High Court, where the High Court determined in case HH 100 of 23 that the lingua of our court is English, and therefore it was, to me, it felt that it was a good contribution to the court, because my clients have been convicted because the lower court used an affidavit which was written in Shona to convict them, and we had managed to convict, wherein we really wanted courts to stick to the procedure, to stick to the law in convicting the people.
Thank you. Thank you, Chief Justice.
Thank you, Chief Justice. Mr. Muzana,
Thank you.
would you rate your law firm as successful?
Truly, I would do that, Commissioner. We started our law firm in 2020. We have represented various people from the lower court up to the Supreme Court, doing the best that we can for our clients. And therefore, in that regard, I do take our law firm as successful. It's not as big as other law firms, but it has managed to find a niche in the market, and also doing the best that we can, giving the people the service that they come for.
Which are your major areas of practice?
My major practice, actually, my main area is the criminal law as well as civil law. Actually, I've practiced the criminal law and civil law. These are the main areas that I practice in, though I've also gone to the labor court, but I would say my main area is the criminal law, followed by the civil law.
Have you done civil trials in the court lately?
Actually, lately what I did in the High Court was, the one which I did lately was an appeal in the civil court of in the Masringo.
Thank you, Honorable Chief Justice.
Honorable CJ. Good afternoon to you, Mr. Muzana.
Afternoon, Judge President.
Yes, as a judge of the High Court, what factors would you consider in determining the quantum of damages in a delictual claim?
In the quantum?
In a delictual of damages in a delictual claim.
Delictual. Number one, I would look at the injury that has been caused, which leads to the delictual claim at hand. And secondly, I would look at the wrongfulness of the person that have caused. Actually, you may find that some other delictual damages will come from where damage is actually accidental. So I would look at the causative aspect, the person whom the litigant is claiming against, how wrong was he, and look at that. Number three, I would also look from the doctrine of stare decisis, would look at the previous cases, how if our courts made or determine or the quantum that they've made before. Actually, our courts would not work in a vacuum where they would simply give a judgment. We need to do a research and see what quantum or what amounts have been given by the High Court before, or even those which have been given by the Supreme Court, so that we have a judgment which is uniform with the other judgments which have been given by the court before.
Very well. Now that you say you want to be a judge, please tell us about your judicial philosophy. Judicial philosophy.
My judicial philosophy is that the court is a place for the truth to be exposed, where the people come in with their partisan sides. They would want, actually the litigants are talking with a partisan lens. They are looking at things from their side. So my philosophy would be to hear the matter with impartiality, hear the matter and hear both sides, the auditorium partem, hear both sides and determine what actually transpired and what is actually that which the law should do to redress a problem that arises in any matter. So my philosophy would be to say I'll be there to determine the truth, to determine what actually transpired. When doing so without any fear or favor, so that our courts becomes places of justice.
Thank you. Thank you, Honorable CJ.
Yeah, thank you.
Mr. Muzana, good afternoon.
Afternoon, Commissioner.
So, as I was looking at your CV that you provided, I know the other commissioners have spoken about the gaps, and I will also just labor on other things that I find quite amiss. It states that your ordinary level education was completed in November 2021. You also show subjects that you did at O level and A level. There are no symbols. I'm not sure what to make of that. It appears that there are gaps that, of course, then you mentioned what those gaps are. Now, how does that reflect on your attention to detail and thoroughness, which two are essential characteristics or attributes of a judge? Please comment.
Thank you, Judge. Thank you, Commissioner. The actual issue is I have not been looking for a job for quite some time. So when I was nominated for this post, actually I was nominated on the 2nd, actually it was the last date. I had to draft a CV, as I then thought I should do. Actually I did everything on the 2nd, which was the last date. But it was actually, I had to rush, give the papers. Actually I think my certificate is on the part of the papers wherein I completed my O levels in 1994, did my A levels in 1996, and I actually did maths, physics and chemistry at A level, which is the reason why I then went for engineering. But as I'm saying, actually I was not looking for a job for quite some time. I didn't even have a CV. I was doing my practice, which then when I was given this idea of saying, I'm going to nominate you, I had to be, then I made myself available for the post.
I also see that you did not attach your certificate for your bachelor's. You earned your bachelor's through which university?
I did my Bachelor of Laws, yes, I finished in 2013. I think as I said, I was approached on the 2nd.
No, it's fine. I think I understand
yes,
what you mentioned.
I submitted my transcripts, which are part of the papers.
Mr. Muzana.
Thank you, Commissioner.
Good afternoon.
Good afternoon.
You mentioned that you are an avid writer and you have written a number of poems and you have had publications. The form that you filled in was talking of publications related to law. And why haven't you, because you are interested in law, that's what you said earlier on, why haven't you written anything related to law in the legal field?
Actually, it's an area that I've been thinking of actually to assist in the development of law, is to start writing in the law. Actually, I've not, as I've said, my writing was mostly for recreational purposes, but it's an area that I've actually thought of recently, to say that I can contribute to the law through writing, but it's something that have not crossed my mind before.
Through your limited experience in the legal field, that is in practicing as a lawyer and also as a judicial officer, what makes you feel that you are mature to become a High Court judge?
Thank you, Commissioner. Actually, as I've said before, I've been a legal practitioner for the past 8 years. This is my 9th year, which I feel that I've gone to the High Court, I've gone to the Supreme Court, I've tried my level best reading the legal books, and I do believe that if given an opportunity, I can be of use to the High Court and also contribute to the development of our legal jurisprudence.
Yes, thank you.
Thank you, Chief Justice. Good afternoon.
Afternoon, Commissioner.
Yes. What values and principles do you prioritize in life, and how do these align with your aspirations to serve as a judge?
Wonderful. I'm sorry, Commissioner.
Your values and principles in life, and how do they align with your aspiration to serve as a judge?
Number one, I would put that I do value the truth as being truthful is a very important aspect of life, wherein things should be put in their proper perspective. And I do believe this is a very important tenet even on the bench, where the people will be judged by what they bring, what is in their founding papers, and what they've said in court, without any other addition. Then number two, I also value to read widely, like has been exposed in the 4 qualifications that I have as well. And I do believe this is a very important aspect for a judge, so that when you are giving a judgment, you need to read widely and understand the particular law or the particular areas of from the area of law that the problem is coming from, and so that when you give a judgment, it needs to reflect on the current law of the country. Actually, the law is one area which is always changing, and therefore you need to be very much aware of the changes that happens, and those changes you can only get to know them if you are reading widely. And something that I value as well is prompt actions. A person needs to act without procrastinating, and that would be very good for a judge, because we do not want to have a very big backlog that will affect the proper administration of justice. People should not take a very long time waiting for a judgment. The judgment should be passed within the acceptable limits which are given by the court.
Thank you. Yes, thank you. We have come to the end of your interview. You are excused.
Thank you.